Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for arguments in Ross Dress for Less, Inc. versus Westfest, LLC, our civil number 12-0703. Each side will have 20 minutes within which to make their arguments this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to manage your time in that regard. We have reviewed the briefs, have conferenced the case. We're familiar with the issues that are being raised here and the facts underlying those issues. So please take that into account as you make your arguments here this morning. As you approach the podium, please identify yourself. We are recording this both in terms of audio and video, and so at some point you'll be able to go to our website and look at the video of this oral argument if in fact that's something you'd like to do or your client would like to see. With that, Mr. May, yes, you may proceed.
Good morning. Thank you, Your Honor. May it please the Court, my name is Philip May. I represent Ross Dress for Less, which is the appellant and cross-appellee in this case. I am contemplating spending most of my time discussing Ross's appeal, although we are also defending the cross-appeal in this case, and unless the Court directs otherwise, I would deal with the issues raised in the cross-appeal just briefly and then reserve whatever time I have left for rebuttal.
Please proceed.
The dispute in this case has to do with the terms and conditions set forth in the lease was executed back in 1997. Ross has been, and this is a significant issue for the Court to appreciate, Ross has been paying its rent consistent with the expressed, clear, and unambiguous terms of this lease from its inception through the dispute and remains on the premises today. It has never deviated from compliance with the clear and unambiguous terms of the lease with regard to rental payments. Never has. In this case, there's no dispute that the lease contains a highly material co-tenancy provision. That's important for Ross because Ross is a retail store. Ross asked and Westfest agreed to ensure that particular co-tenants or their replacements would always be in the premises, in the mall, and that would facilitate foot traffic, which is obviously highly material and important to Ross with regard to its business. The lease provides clearly and unambiguously that in the event that there is a violation of that co-tenancy commitment by Westfest, that minimum rent and or percentage rent would be calculated in a particular fashion, and that would arise if there was a reduced occupancy period. That provision is clear and unambiguous, although the Court will have noted confusion by the trial judge in its initial ruling. That provision is clear and unambiguous, and even in the answering brief they articulate its meaning and its consequence. The parties also negotiated at arm's length a provision, paragraph, I believe it's 9.2, that says that there is no implied covenant of continuous operation. It is an expressed provision establishing the absence of any implied covenant of continuous operation, meaning Ross negotiated at arm's length between these two commercial parties the right to cease operations without the cessation being violating the lease.
But what in the lease links paragraph 9.2 to paragraph 7.2 about reduced occupancy and how the rent is calculated?
I don't know that other than the fact that the lease is an integrated contract, an integrated whole, I'm not sure that there is a link between the two other than the natural consequences of the clear and unambiguous terms of the lease. So let me proceed to the dispute and then talk about the issue that you raised, Judge Downey. So we have wrestled between Ross and Westfest over this co-tenancy provision, as the court knows before. There was an initial litigation that began, I believe, in approximately 2009. First of all, they have failed to provide the co-tenants beginning in 2004. And so we've been in a reduced occupancy period for many years. In 2009, Westfest believed that it had cured its failure to provide adequate co-tenants. A dispute arose. We went to the Maricopa County Superior Court. Ross prevailed on summary judgment, and in fact, a judgment was entered in that first case in April of 2011, well after this dispute was underway. Ross, about 12 years into its lease, a lease that could extend for 30 years if all the options are exercised, decided that it wanted to refresh the premises and remodel. And it advised, dutifully, Westfest of its intent to do so. And Westfest indicates in its answering brief the facts and circumstances that led to that remodel period, and they include this, that Westfest took a look at the lease, understood that through its failure to provide co-tenants that there was a reduced occupancy period, understood that for years paragraph 7.2b had been in effect, and understood that during the remodel period there would be no sales, and understood that as a result of that, the application of the lease provisions would result in neither the payment of minimum rent nor percentage rent during the period that there were no sales. It understood that. And there are two letters in the record that reflect one in advance of the remodel period and one at the beginning of the remodel period, when they say, gee, Ross, how about you pay an average of what you were paying before for percentage rent?
Mr. May, one concern I have, and I also have this question for Mr. Blair, is you started out by saying the terms of the lease are express, clear, and unambiguous. Why then would we look at course of dealing, intent, those sorts of things?
Well, the issue of course of dealing that's raised in our brief, Your Honor, has to do with the trial court judge's initial determination that minimum rent applies no matter whether there's a reduced occupancy period or not. That's his initial ruling, and we talk about course of dealing there by saying, look, Westfest didn't make that argument to the court. We didn't make that argument to the court. We both recognize that the literal application of the terms of 7.2b results in neither minimum rent nor percentage rent paid during that 5-month period. We both understand that. We recognize that. The trial court didn't understand that or recognize that in its initial ruling. It said, gee, the way I read this, you pay minimum rent straight through. It wasn't until motions for reconsideration were filed that the court came to a different determination, which was essentially, I'm going to alter this lesser than language in paragraph 7.2b, and I'm going to require actually a stepped up rental obligation payment, even though there's nothing in the lease that supports or provides for that.
I asked the question because I was understanding your argument to say we should look at letters that were exchanged between the parties and interpretation, which seems to me contrary to a claim that this is an express, clear, and unambiguous, or that the terms are express, clear, and unambiguous, and no one really went through the Taylor versus State Farm factors to determine whether extrinsic evidence should be admissible on this issue.
You know what, Your Honor, let me explain why I introduced the notion that it was clear to Westfest. Westfest takes the position that, gee, we would never have known this. There's in the record an affidavit that's 2 sentences long from Mr. Decker, who doesn't say that he didn't intend this consequence. He just says that I never even considered the possibility. That's their position, and that appeared to have some influence on the trial judge. And our response to that is, well, you must have, I mean, it was obviously ascertainable, because even before we entered into the remodel period, you were contacting us and saying, gee, why don't you, because they recognized that they weren't going to get paid anything if there were no sales, because they've been getting paid percentage rent for some time, because they had failed to honor the co-tenancy commitment obligation. So I'm introducing that to rebut the notion that this was unknown or unknowable. The fact of the matter is, their rationale from the inception has been, citing to the Walgreens case and the First American case, and saying, gee, when you have a percentage rent situation, it's unique. And the courts have, in this state, in two instances, in these 2 cases, have looked at a percentage rent circumstance to determine whether or not the court could fairly and appropriately, notwithstanding the rules of contract interpretation alike, imply a material provision that requires continuous occupancy, because where the percentage rent is the only rent or is the predominant rent, those courts were willing to take a look and see whether or not they could imply that covenant of continuous occupancy.
Well, you're not really talking about a covenant of continuous occupancy. You're talking about an implied covenant to keep the business open for retail sales so that there's a basis upon which to assess the percentage rent.
The precise language of the court's implied covenant, I think it's of continuous occupancy, but the point is what you make, and that is, if it's a percentage of sales, then do you have to remain open or are you in material breach? And in the absence of any language at all in the lease, can the court appropriately imply that covenant? That's what the Walgreens case stands for, and that's what the First American case stands for. And in both instances, they show the great restraint that the courts have in doing so. And among other things, they say there can be no implied covenant where the subject is completely covered by the contract.
Did either of those cases involve this situation where there's an alternative presented? It's either a minimum rent number or a percentage number?
No, they didn't. In fact, I would say that they were much more compelling with regard to the courts overcoming the rules of contract construction in those cases. In those cases, in this situation, just to be clear, we are only talking about a reduced occupancy period because Westfest's failure to provide the co-tenants that it committed to. Okay, so one way that we avoid this consequence for this brief period of time, 5 months in a potential 30-month or 30-year period, is for Westfest to cure its co-tenancy breach. So we're in this unique situation, not because of anything that Ross did, but because of something that Westfest did, all right? So the issue is, if your sales go down and down and down and down and down, then that percentage rent goes down and down and down and down under 7.2b. Their position is that's okay until you get to that last sale or that last widget or that last shoe, and then all of a sudden you have to pay minimum rent, which you haven't had to pay since 2004 as a result of our failure to provide the co-tenants. And there's nothing in the lease. There's nothing in the lease that suggests that the consequence of us doing what we're entitled to do under the material terms of the lease, which is to shut down and remodel, which, by the way, costs a lot of money and enhances the property that we're remodeling, and then come back in and reopen, and the evidence is we paid every nickel we owed under the terms of the lease. And if we were to take a look at the cases that they cited at the time that they were demanding that we pay minimum rent, notwithstanding the fact that that demand was contrary to the express terms of the lease, and there is no provision in the lease that even could be implied to require that, they then directed us to cases that say you don't have a complied covenant of continuous occupancy if the lease expressly deals with that issue, which it does here. So they're saying pay more than you've ever paid before, despite our violation of the co-tenancy clause, or risk eviction. And our reaction to that was, we are going to pay precisely what's due under the lease based upon its clear and unambiguous terms, and when we reoccupy the premises, we'll continue to pay, and we did that, and it wasn't until 5 months after we had reoccupied that they decided that they wanted to argue that there was a termination. So, at that point, we did what we did essentially the first time around, and that was, we said, if we're at loggerheads with regard to this, if you're demanding that we pay a rent that we haven't had to pay because of your violation of the co-tenancy provision for 5 or 6 years, and you can't point to a provision in the lease that requires it, and in fact we're entitled to shut down and remodel, enhancing both our business and your property, we're not going to pay that money. But what we will do is we'll go to court and we'll talk to the court about your position and our position, and we'll abide the outcome, which is what we did. Now, in the interim, they filed a forcible entry and detainer action against us. It was reassigned to Judge Herod, who then had both cases going at once. We filed a motion to dismiss. He converted it to motion for summary judgment, granted the motion on the grounds of the disputed sums clause, and I've got a deck action. I'll resolve these things in my court. And then we went through the process, and you have the record. It was resolved in cross motion for summary judgment at that point. And again, initially the judge's ruling was that minimum rent is just due, and that was just wrong, and it was unsustainable and never argued by either party. And then when we came back on reconsideration, he argued that it just didn't seem right to him. Essentially, it just ain't fair that for this brief period of time, the foreseeable consequences of the cessation of operation when you are in a reduced occupancy period because of your failure to provide the requisite co-tenants. You're going to be paying neither minimum rent nor percentage rent, but you're going to continue to pay consistent with the balance of your obligations under the lease. And in this case, that was $38,000. We enhanced the property, we paid the money, we complied with the precise terms of the lease, and have done so from 1997. What this really is about, I think as much as anything, is embodied in the cross appeal. And that is that Westfest, for some reason, finds this to be a disadvantageous lease. They don't like the material commitments that they made, and they want to terminate it. And that's the basis for their cross appeal. And of course, on that score, I think the trial judge looked at the circumstances and say it's hard to hold Ross accountable for failing and refusing to pay a sum that is not due under the lease and is only due because I've decided as a judge that I'm going to alter the material conditions of the lease and direct you to make the payment. It's really hard to say that you should have contemplated that in advance and that this isn't a legitimate, bona fide, good faith dispute. So I'm going to consider those things, but I'm going to find your argument in good faith but unreasonable, and I'm not going to allow Westfest to terminate the lease. So if we get to that point in these discussions and in your consideration of the appeal, I would ask certainly that this court understand that Ross could and should have done nothing else and put yourself in a position of commercial tenants and landlords in this community and throughout the state. What do you do when you're accused of violating a lease, but you're in full and complete compliance with its material and unambiguous terms? And that what you do is you comply with them, you honor your commitment, and you expect the party with whom you've entered into that contract and with whom you've had a contractual relationship with 12 or 14 years to do exactly the same.
Thank you, counsel.
Good morning, Your Honors. May it please the Court, my name is Michael Blair. I'm counsel for the appellee cross-appellant Westfest. Nothing is more important to a landlord than rent. Rent is always due from a tenant to a landlord unless it's specifically excused in the lease. In this particular case, we had a 210-day window following the rent commencement date, or the lease commencement date, wherein no rent was due. Otherwise, the entire 40-some-odd pages of the lease always said the tenant shall pay rent. Always has to pay rent. Now, what we have here is a tenant who decided they were going to combine two terms of a lease that are not linked. They wanted to say, well, we got this co-tenancy clause and we're paying percentage rent, but hey, we've got this other term that says we can shut down and it's not a breach. Well, if we shut down and we have no sales, then we don't have to pay any rent. We can stay there for 5 months for free. Well, you can't do that. The lease required rent to be paid. The trial court specifically found that Ross's refusal to pay rent was based on an unreasonable interpretation of the lease. That was a breach. Westfest then complied exactly with the negotiated terms of the lease and gave Ross notice, time to cure, and they didn't. We actually gave them time to cure twice, and they didn't cure either time. And that gets into our cross appeal. But let's look at the appeal first.
Counsel, Mr. May, if I understood him correctly, characterized your failure to provide the proper mix of co-tenants as a breach of the lease. Do you agree with that characterization?
I do not, and here's why. First off, it's a distraction because it's not. That was never an issue in this case as to whether we had provided the appropriate co-tenant mix. So that's not an issue here. Secondly, it had been in a co-tenancy position, a reduced occupancy position for several years, not because of any fault of our own, but because of the economy. Circuit City and Bashes both went bankrupt and had to leave. Now the remedy Ross had.
But
okay.
Again, does the record show how many years that was?
No, and I don't know if that's necessarily in dispute, whether it's 2005, 2004, 2006. It was several years. We admit that.
And again, before we leave that area of inquiry, does the record show over the years what Ross paid? As opposed as the percentage sales as opposed to minimum rent?
They did pay percentage rent during those times. There may have been and it's not in the record, but I'll just proffer to the court. There may have been a month or two, like a December, where you had some good Christmas sales where they had to pay in addition. But for the most part, for the vast majority of those years, it was percentage rent. But the key distinction here, Judge Thompson, that you got to remember is they were open and operating that entire time. The only time they closed and weren't generating sales was these 5 months at issue here. Now, the relief provided in the lease, if there's a reduced occupancy period that lasts for longer than a year, Ross could get out. That was the relief given to them. The terms in Section 7.2 says they can terminate upon 1 year's notice. Well, if they didn't like it, they could just say, this isn't working. We're not getting the mix of other tenants. We're not getting the draw here that we want. We're just going to leave. They didn't do that. They paid percentage rent, and we admit that they did pay percentage rent. But they were always open and operating. That's the distinction. And so we get to Judge Downey's question about if the terms are clear and unambiguous, why do we look at the course of dealing? The issue is the course of dealing that happened for those several years when we were in this reduced occupancy period was they were generating sales. We get to this one point where we come to September, October 2010. They say, we're going to shut down and reformat our store.
Well, that's a fact, and I think facts are properly considered, but where I had some difficulty is I think both sides to some extent talk about course of dealing for other purposes to support how they interpret the contract, and that's where I had the problem because I don't think Taylor versus State Farm was necessarily followed or even discussed much, and it seemed to me that I heard Mr. May say, and I think you're also saying, that these contract terms are clear and that we don't need to resort to extrinsic evidence to interpret them. Is that true?
Well, it's true, I think, to a point, and it's more true on the appeal side. So let's talk on the appeal side for just a minute, because, we really do have a reduced occupancy period. That's what the lease says. You can look at that provision, and it says if you don't have the co-tenants, you pay percentage rent. Okay, we agree with that. You also have Section 9.2, which says, hey, Ross doesn't have to open. We can go dark if we want. That doesn't talk about rent. It just talks about use. It talks about operation. If you look in Section 9.2, there's not a single mention in there about rent. It's just operation. And our position with that is, hey, if you want to go dark, you're going to pay us rent because we're not going to let you just have our property without paying rent.
But Section 9.2 doesn't say that.
It doesn't say anything about rent. It just says you can go dark.
I think Mr. May's point is that West wants to rewrite 9.2 to explicitly say, in the event Ross exercises its contractual option to close its retail operation for a period of time, that there still remains an obligation to pay some form of rent, whether it is the minimum rent or whether it would have to be minimum rent.
Correct. And I don't think it's a rewriting of it because Section 9.2 doesn't deal with rent. It just deals with operation. Every other term that deals with rent in the lease says tenant shall pay rent. Tenant shall pay rent. Rent was absolutely required, except for that first 210 days. You had to pay something. You can't just come into our store and say, well, okay, there's a co-tenancy. We're going to go dark because we don't want some of our competitors to come in. And now you've just locked up our property for 30 years, 15 years, whatever it may be. You got to pay something. If you want to use it for storage and go dark, pay us minimum rent, that's fine, but you're going to pay us. You have to pay the rent. And so with that, back to Judge Downey's question, we do have those two terms, but there's nothing linking it.
So I'm understanding you to say, at least on the appeal, you don't argue that extrinsic evidence, course of dealing, parties' intent is something we need to delve into.
I don't think so on the appeal, Your Honor. I think that is fairly clear. And if you look at Judge Herod's April 17, I believe it's April 17, minute entry order where he clarified his decision. This is document 52 on the record on appeal. He specifically finds that those two, 7.2b and 9.2, are not linked together. And if you do, it would reduce the clause to nonsense. It says, Ross's construction of the reduced occupancy clause would allow it to voluntarily close during a reduced occupancy period and pay no rent. This could allow him to tie up the property. It reduces the clause to nonsense.
I think at times he also discussed it would be unreasonable. And, of course, a court will enforce contract terms whether they're reasonable or not if they're clear. So we don't delve into reasonableness here, do we?
I think the reasonableness gets to our cross appeal where we get to a breach, because we said, hey, that was an unreasonable, that's a breach. You didn't pay. And so we put them on notice twice, gave them time to cure twice. They didn't. They didn't raise the disputed sums. They didn't do anything else. And so that is the time where you get into whether, I guess, reasonableness of their actions. We put them on notice. They didn't cure. We terminated the lease. Now, if we get into the cross appeal for just a minute, I think that's where some evidence of extrinsic evidence, intent of the parties, maybe not intent of the parties, but more along the lines of course of dealing of the parties would come in, because...
Ask you about that. You're saying the disputed sums clause requires consideration of extrinsic evidence and can't be resolved on the face of that?
No, I think it could be, but I wanted to explain why we brought up some of that, some of the other information. We had the prior litigation where they did not raise the disputed sums clause.
I get where that helps you if you get into a Taylor versus State Farm analysis, but do you have to go there?
I would say you could resolve it just on the terms of 37.17, because I think that's clear enough in and of itself that it is not intended to trump the other parts of the lease that deal with payment of rent, that deal with us putting them on notice of default, giving them time to cure, and then if they fail to cure, us allowed, the landlord being allowed to terminate the lease.
Is the term charges synonymous with rent under this lease?
Well, therein lies a rub. We say the charges, as defined in Section 3717, relates to the items that are defined therein, which are, without limitation, taxes, common area charges, insurance reimbursement, and other items. Now, they want to say that rent is thrown in there, but if we look at the phrase before that, it says charges may be due from tenant to the landlord and vice versa. Well, landlord never has to pay a tenant rent. The things that a landlord may have to pay a tenant is if there's a discrepancy over the CAM charges, over the taxes, you do a reconciliation at the end of the year, and oh, well, we overcharged you, so now we owe you X $1,000, and you've got a dispute there, that things that the landlord could actually have to pay, but you don't ever have to pay rent. There's not a dispute in that particular item. So if they want to say, oh, you can throw rent in there because you've got without limitation, well, it doesn't address minimum rent or percentage rent. Now, they also want to say earlier in the lease, in Section 7.1, that rent means all minimum rent, percentage rent, and other charges which may be due from tenant to the landlord. And therein they try to bootstrap in CAM charges, insurance, taxes, things like that. Well, let's suppose for a minute that instead of percentage rent, they decided that they didn't want to pay insurance or something. Well, Section 37.1 allows us to put them on default for any, Section 25.1, not 37. 25.1 allows us to put them on default for any monetary payment that is not paid. Well, if they weren't paying insurance, for example, we could put them on default for that. They couldn't say, well, hey, we've paid minimum rent, we've paid CAM, we've paid taxes, we just didn't want to pay insurance. You've already got enough here in the other things, you can cover your own insurance. Well, no, they had to pay all four of those items. Insurance, CAM charges, taxes, and rent. And now whether rent's minimum rent or percentage rent, they had to pay it. So their argument here that, oh, we still paid $38,000 while the store was closed, well, those were expenses. They were obligated to pay those anyway. What they didn't pay was the key thing that the landlord always needs, and that's rent. They didn't get the rent. Now, how do you figure out what the rent is? Well, in a reduced occupancy period, it's either 2% of sales or the minimum rent. If you don't have sales, it has to be minimum rent. I mean, it just is a matter of logic. It's not 2% of nothing. They want to say 2% of zero is zero. Okay, well, but it's really 2% of nothing because they had no sales. So it's you cannot use the percentage rent if you are not having any sales. Now, let's go to the cross appeal for a minute. On two occasions, we gave them notice that they were in default, that they needed to pay. Both times, they snubbed their nose. They said, nah, we're allowed to do this. 9.2 lets us close, and since we don't have sales, then you don't get anything, tough luck. They never, in either of their responses, on either November 24th in response to our November 16 notice of default, nor in their August 3rd response in response to our July 22 notice of default. They never raised the disputed sums clause. They never even thought about it until after we terminated the lease. Now, how you can invoke a clause after the lease has been terminated is unknown to me, but the trial judge essentially split the baby and said, well, Westfest, you get your rent, but Ross, you get to stay in the property. Well, you can't do that. We had a negotiated right in section 25.1 that says you can terminate the lease. If there's a breach, you got to give notice. It's a standard clause in almost all commercial leases. Give them notice. For a monetary breach, they get 10 days to cure. For a non-monetary, they get 30 days to cure. They didn't cure. They could have done all sorts of things. They could have said, we think the disputed sums clause applies. We're going to go ahead and pay the money into an escrow, or we're going to file suit within those 10 days and pay the money into court. We're going to do any sort of thing like that. They didn't. They just said, no, we don't owe anything. 2% of zero is zero, which is the wrong question. It should be 2% of nothing because there were no gross sales. And so we put them on notice. They never cured. The lease specifically says, upon the default, which is an uncured breach, landlord, upon written notice, may terminate the lease and retake possession of the store. We did exactly that on August 30th. We gave notice that the lease was terminated. 3 days later, they come back and said, whoa, wait a minute, you can't terminate. We've got a disputed sums clause. And so you can't do that. Well, if you look also at the disputed sums clause, Your Honors, and I think it's clear. But if it was clear, I suppose we wouldn't be here. But in 3717, it says, a bona fide dispute arises with respect to the amount due. Well, there was never a dispute about the amount due. It was always rent. The dispute that they raised was, do they have to pay it? I mean, they knew there were no sales, so it couldn't be based on percentage sales. It had to be minimum rent. It had to be a bona fide dispute over the amount due, not a bona fide dispute over the lease interpretation that they had that they didn't have to pay anything. And so the amount due was always minimum rent, and there's never been a dispute. It's always been the $85,000 for those 5 months. We put them on notice. They didn't cure. We terminated. The trial judge erred by not allowing us to terminate the lease. I'm going to save the remainder of my time, unless there's any questions, for rebuttal on my cross appeal, unless the court has any questions.
Thank you.
Thank you.
Mr. May.
Thank you, Your Honor. When Westfest wants to talk about the disputed sums clause, they talk about we negotiated this rights under paragraph 25.1, and the contract is the contract, and they didn't pay the sum that we said they owed under paragraph 7.2b by taking out the lesser than provision. And since they didn't acquiesce to our interpretation of the lease, which requires something, implied provisions or something, a nullification of some provision, then they're in material default, and we get to adhere to the principles of contract construction. And in their brief in support of that position, they confirm what we all know, and that's that where parties bind themselves to a lawful contract, the court must give effect to the contract as written, and clear and unambiguous terms are conclusive. An erroneous but good faith interpretation of a contract cannot protect a party from contract liability. A valid contract must be given full force and effect, even if it's unwise or improvident or its enforcement is harsh. Those are all quotes from their brief. And it's on the basis of that black letter contract law that the court should reverse the trial court in its determination that somehow paragraph 7.2b needs to be revised to provide a unilateral benefit that they didn't negotiate in the first instance. And let me when I ask the court a rhetorical question, because I haven't figured this out, what's the legal theory here? It is not based upon these cases, because these cases stand for the proposition if the cases, the Walgreen case and the First American case were set up as follows, that there were cases and it was all percentage rent, commercial cases, and there was a provision, as we have in our lease, that says that there's no implied covenant of continuous occupancy. If those two circumstances were together, the Walgreens case and the First American case would say, well, it's rough that your lease provides that you only have to pay CAM charges and insurance and other things, but it precisely says you can close down and not operate, and so you're not going to be paying percentage rent, and that was foreseeable at the time you executed the lease. That's what those cases would stand for, because they say we're not going to imply that covenant. We're not going to force that material term by implication on the parties where the subject of the implied covenant has been dealt with by the parties, and where it can't be deemed to have been necessary and intended by the parties. And you can't get there here. What's the theory upon which, counsel says during a reduced occupancy period you either pay, this is exactly what he said, minimum rent or percentage rent? That's what 7.2b says. No, it's not. It says you pay the lesser of minimum rent or percentage rent. Absolutely foreseeable at the time that this lease was executed that the co-tenancy provisions would not be adhered to, 7.b would apply, and we would shut down during this potential 30-year lease term to refurbish for a brief period of time. Absolutely foreseeable. They could have negotiated a different result. They didn't. So what is the legal principle upon which the trial court or this court alters those material terms? They don't disagree that no sales for a period of time when it's the lesser of minimum rent and percentage rent means nothing.
Let me ask you this, Mr. May. Under your interpretation of the contract, assuming there's a reduced occupancy period, could your client simply quit operating as a store and use that facility for storage without paying Westfest?
I would have to go through the whole lease and see whether or not it's supposed to be operated as a retail provision, unless I don't know the answer to that, because this is a 30 or 40-page lease. But what we can do is we can.
That seems to be a logical extension of your argument. If you're saying there might be some provision that requires them to operate as a retail store, then that would seem to make trouble for you on this appeal. So that seems to be the only logical extension of your argument, is they can shut down during a reduced occupancy, use the premises for storage, warehouse, whatever, and pay no rent.
I think I'm going to be reluctant to answer that without looking at the whole provision. I just scanned 9.2. We can cease retail operations. Whether there's alternative uses that we could employ, I don't know. I'd have to look at the balance of the lease. But clearly, 9.2 specifically says we have unfettered discretion to cease our retail operations. Clearly, it says that. We're also, as the record demonstrates, paying a significant sum of money on a monthly basis to maintain our percentage of the common area charges and the balance of the charges. So
in this instance, where Ross chooses to not operate and has access to the premises and use of the premises for whatever purpose it deems appropriate for itself, it gets to do that for free and not pay any rent at all.
During a reduced occupancy period, and only during a reduced occupancy period, based upon the no implied covenant of continuous occupancy, which they negotiated at arm's length, and a group of attorneys or a group of seasoned or not so seasoned professionals who own and lease land would sit down and look at this lease and say, okay, well, this is a foreseeable consequence. Let's negotiate this. Okay, that is a possibility, but we would always be paying rent. And to answer Judge Downey's question about rent is defined as all charges and payments that are made under the lease. And I call your attention to the last sentence of paragraph 7.1 that says the terms rent or rental shall mean minimum rent, percentage rent, and other charges, meaning those are charges, as well as other charges, which may be due from tenant to landlord pursuant to the lease. Rent is a charge under the lease. Just to toggle over to the issue with regard to rule or provision 3070, the disputed sums clause.
Thank you, Mr. May. Appreciate your argument. Mr. Blair.
Thank you, Your Honors. Look at Section 9.1. Section 9 altogether is use. Section 9.1, well, 9.2 contains a no implied covenant of operation, not occupancy. It's no implied covenant of operation. Lets them go dark if they want. Look at Section 9.1, though. First sentence, the store is intended to be used principally for the sale of soft goods.
Are we talking?
Okay. Still look at Section 9.1. With the cross appeal, Your Honor, again, I guess there's not much for me to say on rebuttal because nothing was said on his rebuttal about the cross appeal, which I think is telling because they have no defense to the fact that they did not cure. We gave them notice. They didn't cure. Now, if you're in that position, What other rights does the landlord have other than to terminate the contract? We negotiated this term, Section 25.1. It gave us the right to do so. And if we're not allowed to terminate the contract, they are eviscerating Section 25.1 right out of the deal, or right out of the lease. They want to say, oh, there was a good faith dispute. Section 25.1 and Section 3717, the disputed sums clause, are also not tied together. 3717 is in the general conditions, the last part of the lease. You'd think if this was such a critical issue, it would have been included in the part which allowed us to terminate the lease. It wasn't. They're not tied together because the disputed sums clause dealt with other charges for things that the landlord may have to pay the tenant. Rent doesn't go that way. It only goes one way. They didn't cure. Nothing was said about that here because they have no defense to that. They can't avoid the consequences of their own negotiated lease. They agreed that if they were in default, we gave them notice, they didn't cure, we could terminate. We did that exactly. And the judge, frankly, erred when he decided, no, there was a good faith interpretation, even though that interpretation was unreasonable. You can't go that way. Once the interpretation was unreasonable, once they were in breach, they're in breach. You can't have equity come in and save them and say, you know, it's okay, you guys were sort of fighting about this. I'm going to let you have your rent and I'm going to let you keep the premises. You can't do that.
But what about Mr. May's argument that, as defined by the contract, charges are synonymous with rent, which brings the disputed sums clause into play?
It could be. I suppose you could make that argument. But if you look at the entire 3717, you've got other charges due from landlord to tenant. Now, rent, like I said, rent doesn't go that way. And you've got that the Latin maxim of expressio unius est exclusio alterius. Excuse my Latin. I apologize for butchering that. But by saying the things that they really meant, that's what they intended. Those are the specific things that they intended. If they wanted to throw rent in there, they certainly could have. They did say insurance. They did say CAM. They did say the other thing. And then they just did a general, well, including without limitation, blah, blah, blah. But they specifically said 3 of the 4 things that are defined as rent in Section 7.1. So with that, unless there's any questions, I'm going to sit down.
Thank you, counsel. We appreciate the arguments of both counsel, the briefs that were filed. We're going to take this matter under advisement. We'll issue a written decision in due course. We stand adjourned.
Meeting like this. It's sort of a never-ending thing, isn't it? Let's see it. Thank you. Thanks.